graduate of The Ohio State University and Capital University Law School, attorney Fred Voigtman is admitted to practice law in Ohio and California, as well as before the United States Federal District Court in the Central District of California. As an attorney in good standing, Mr. Voigtman may represent clients from any country in the world before any United States immigration office. Mr. Voigtman's staff consists of experienced paralegals and legal assistants who speak many languages and assist in client communication and case preparation. During the past 18 months, Mr. Voigtman has been the attorney of record in over 80 successful EB-5 immigrant investor petitions.
Hello, my name is Fred Voigtman. Thank you for watching this informative EB-5 video on the immigrant investor law. I'm a U.S. immigration attorney specializing in EB-5 immigrant investor cases and other employment-based immigration matters for clients wishing to immigrate to the United States. I have practiced U.S. immigration law for more than 20 years, having worked in Taiwan from 1993 to 1997 for my father, who is also an immigration attorney. From Taiwan, I was hired by Maurice C. Inman Jr. in 1997 to come to Los Angeles and work in his growing EB-5 immigration practice. Mr. Inman was the general counsel for INS in the Reagan administration from 1981 to 1986, and he was one of the early architects and proponents of the EB-5 immigrant investor law. Mr. Inman was a great mentor and taught me many things about EB-5. While working for Mr. Inman, I gained valuable experience in representing EB-5 investors from Taiwan, Hong Kong, South Korea, and Japan. I traveled to many U.S. embassies and consulates in Southeast Asia, and I attended many EB-5 immigrant visa interviews. Also, I was Mr. Inman's co-counsel on one of the most important EB-5 cases, matter of Izumi. Mr. Inman and I traveled to Washington, D.C., and we appeared for an oral argument at the Administrative Appeals Office. During the late 1990s and early 2000s, the EB-5 program was largely dormant due to U.S. government restrictions and the uncertainty that these changes brought to the EB-5 marketplace. Only a few hundred EB-5 petitions were filed during that uncertain time, even though 10,000 EB-5 visas per year were authorized. Then, in about 2007, when the U.S. economy began to experience a severe recession, EB-5 developers and regional centers sought to utilize EB-5 capital to fund projects that otherwise could not obtain traditional financing due to the economic crisis. The result was the rebirth of the EB-5 program. The U.S. government finally realized the potential benefits of EB-5 in terms of foreign investment and job creation, and it began to relax some of the earlier restrictions that had limited the EB-5 program. In addition, the U.S. government began to increase communication and cooperation with stakeholders in order to increase efficiency and predictability in the EB-5 process. For the last few years, EB-5 has enjoyed a steady annual increase in the usage of available visa numbers. Although the economy is on the road to recovery, obtaining traditional financing from banks and other lending institutions remains difficult and costly. EB-5 capital has established itself as an important part in many new development projects, both large and small. It is clear that EB-5 is here to stay. Let's talk about some of the differences in the EB-5 program between direct or standalone investments and regional center investments. The EB-5 law is, at its essence, a job creation program. The original law, found in Section 203(b)(5) of the Immigration and Nationality Act, requires that an investor invest a certain amount of capital, either $500,000 or $1 million, into a new commercial enterprise, NCE for short, and that the NCE directly create 10 new full-time jobs for U.S. workers. The original law made no accommodation for indirect job creation. In time, Congress created and passed a pilot or temporary program that allowed for designation of EB-5 regional centers. These regional center projects must meet all of the EB-5 requirements, except that they could rely on indirect job creation instead of direct job creation. The Regional Center EB-5 law was, and always has been, a temporary program with an expiration date. The law has been extended a few times, but it has never been made permanent. The current expiration date for the Regional Center EB-5 program is September 30th of 2015, just over a year from now. If the Regional Center EB-5 law is not extended or made permanent, then all EB-5 investments would have to be direct EB-5 cases. In other words, they all would have to create 10 direct jobs per EB-5 investor. In the case of a direct EB-5 investment petition filed today, there is no concern for any expiration date. The EB-5 law governing direct investments is a permanent law and does not have any expiration date. Another key difference between direct EB-5 and regional center EB-5 cases is that direct investments allow for more control by the investor of the project. A typical regional center project pools EB-5 capital from as little as 20 to 200 or more limited partner investors who have very little individual control or say over how their money is spent. A limited partner investor in a regional center project basically can vote only on general policy matters along with the other limited partners. A direct EB-5 project investor has much more control, if he or she so desires. As for job creation, the regional center law allows for various economic methods to be used to count the indirect and direct jobs. EB-5 economists use complicated inputs and multipliers to project or estimate the number of indirect jobs that will be created by a regional center project. As for job creation, the regional center law allows for various economic methods to be used to count the indirect and induced jobs. EB-5 economists use complicated inputs and multipliers to project the number of indirect jobs that will be created by a regional center project. Sometimes the projections get inflated past the point of credibility, and the USCIS questions, investigates, or even denies EB-5 petitions that do not adequately support the indirect job number projections. Direct EB-5 petitions, ones that involve a Fatburger restaurant, for example, are much more clear in projecting the need for the 10 full-time direct jobs that will be created. Larger regional center projects with hundreds of investors are susceptible to failure if there are a few jobs missing or if there are a few jobs too short. Direct EB-5 investors do not need to share the number of created jobs, as is the case with regional center EB-5. Transparency as to how the capital will be spent is another important consideration. Both the USCIS and the EB-5 investor will demand transparency from the project to see when and how the invested capital will be spent. Large regional center projects often have many classes of expenditures and soft costs that are difficult to see where a particular investor's money is actually being spent. Direct standalone EB-5 investments are much more clear as to the timeline and purpose of all capital expenditures. The construction and operational timelines for each project are heavily scrutinized by the USCIS. Both the investor and USCIS can easily see the timeline of a direct EB-5 project, from the construction, design phase, to pulling permits, to construction completion and then operation. For many regional center projects, construction can last over 2 years and is often subject to delays and cost overruns that can jeopardize the EB-5 eligibility for the investors. When it comes time to open the business and begin operations, it is important for an investor to be able to review or at least have access to daily revenues and expenses and to be able to check up on the project to ensure that it is running smoothly. Most regional center projects leave their limited partner investors without such ability. Finally, regional centers have received a few black eyes recently. There was a widely publicized EB-5 scam being perpetrated on Chinese investors who sought EB-5 green cards in a Chicago Convention Center project that unfortunately did not exist. There have been SEC investigations and other government activity designed to weed out fraud and bad actors in the EB-5 marketplace. These bad actors and the examples of fraud in the EB-5 regional center context have most often been associated with regional centers and not direct EB-5 cases. Another reason to strongly consider direct EB-5 cases over regional center investments. A final and important reason to consider a direct EB-5 investment is that the jobs must be directly created. This would seem to be a disadvantage for EB-5 direct cases. After all, regional centers may benefit from direct and indirect job creation. The problem for regional centers, however, is that the methodology used to predict the indirect job creation is often highly scrutinized and sometimes rejected by the USCIS. If such rejection occurs at the I-526 stage, a regional center investor will not get the conditional green card. If the USCIS rejects the indirect job creation data and conclusions at the I-829 stage, the regional center investor will not be able to receive a permanent green card and would have to leave the United States. For the direct EB-5 investor, proof of job creation is relatively simple because it is direct job creation. Tax returns, payroll records, and I-9 forms are all that is needed to show at the I-829 stage, and it is a much simpler process and easier for USCIS to understand and therefore approve. In conclusion, EB-5 is a complex but important part of U.S. immigration policy. Any potential investor should conduct their own due diligence to determine, 1, if EB-5 is right for them in their situation, and 2, to determine whether they wish to seek an EB-5 regional center investment or a direct EB-5 investment where they will have more control. Once the decision is made to invest in any EB-5 project, the investor should hire financial professionals to independently review all offering documents. Of course, the investor should also make sure to hire an experienced EB-5 immigration attorney.